which is capable of being transferable to another person, that is by assignment. Distributes, or you are going to distribute that particular copyright, or you are exhibiting that particular copyright in public. So here the central government, they will be appointing a person who is called as a Controller General of Patents. Now registration, and within 2 months from the receipt of the application of such copy of the notice of opposition, hi and a warm welcome to you all dear students. I, George Lime, Commerce Faculty, Department of Commerce, Vidhyaashram First Grade College, the Temple of Excellence, MYSURU. Dear students, today we shall take up session 2 of Unit 4, that is on Intellectual Property Acts. Under this, in the last session, I was explaining to you regarding the intellectual property rights meaning and the definition. Then I explained to you which are the acts which is coming under this particular intellectual property acts, and what are the works, and what are the other important aspects related to the intellectual property acts, such as it may be like first one we took up the copyright. I explained to you what is a copyright and what are the registration procedure for registration of a copyright. I was explaining to you. Now in today's session, we shall continue with the same topic. Then we'll move on to the second type of intellectual property act, which is coming under this particular unit called as the the trademarks. Okay, and we'll see the procedure of the trademarks also. So assignment of copyright. In today's session, we shall start with assignment of copyright. Assignment means transfer of ownership. Assignment means what? Assignment means transfer of the ownership. Now the copyright is personally movable property. This copyright can be transferred where it is a movable property, personal movable property, which is capable of being transferable to another person, that is by assignment. So through assignment, this personal property, that is the copyright, can be transferred. So copyright is a bundle of rights. So what is a copyright? It is a bundle of rights which is given to the copyright holder, right? Which may be assigned wholly or partially. So this particular right which has been assigned to the copywriter, he can assign it, transfer it fully or partially, that is in part. The assignee becomes the owner of all that which is assigned to him, and he alone can sue for the infringement of the rights assigned. So under this case, when the owner or the copyright owner, if he transfers his rights on another party fully or partly, then that particular assignee, one who has taken that ownership, that person will become liable, and he will be having full rights to sue any other person if that particular person, the third party, is taking or receiving that particular or using his particular rights, that is the copyrights. The assignment must be done in writing. If you want to transfer your copyright, that is assignment, it should be done in writing, stamped, it should be done, and according to Indian Stamp Act, right? And it says the copyright being a beneficial interest. Now this copyright is a very beneficial interest on part of the copyright holder in the movable property, if it's capable of being transferable. So, and it says this assignment evidence by writing. Now if you want to transfer it, there should be some proof or the evidence for it. So that is the reason why they say that you need to do that assignment in writing, and it has to be executed by the assigner, that is the person who is transferring his rights, the copyrights, or by his duly authorized agent. So he can do it on his behalf or on his own, or on his behalf any agent can be appointed, and he can also do this assignment work. It need not be registered. Now infringement of the copyright, that means if any other third party has received that particular copyright and he is using it illegally without the permission of the copyright holder, then that particular person can be sued in the court of law. So when without authorization from the owner of the copyright or the competent authority or any other act received, it constitutes the infringement. So only when the person is giving the permission, or any other party related to that particular copyright, if they are giving the permission to use that particular copyright, then only the other third party can use it, unless there is no way to use that particular copyright. And in case if that particular third party uses that particular the copyright without getting permission from the owner or from the it may be the agent or any other person, assignee, or it may be the competent authority, then he can be sued and he cannot do that. So it says copyright is infringed by any person when any person, first one, without a license does anything for which the exclusive right is the act conferred upon the owner of the copyright. The first and foremost thing, it says copyright has been infringed when any person So here, if the copyright is being used, that means it is being used without the permission or without the license from the permission or the license which is given by the copyright holder or the any competent authority. Secondly, without license permits for profit any place to be used for the communication of that particular work to the public where such communication constitute an infringement of the right in law work. So it says, secondly, without license, if it is permitting that particular work, that is for profit, if you are doing that particular work or the act in any of the place and that particular place is being used to communicate this particular work to the public, and in such cases where such communication constitute, it will be an infringement on part of the right in work. Third, it says makes for sale or hire or sells or offers to sell. So either whether you are going to sell it or you are going to hire it, right, or you are selling it or you are making offer to sell either by any trade displays. So all this is being done in the form of a trade displays or any otherwise, then distributes or you are going to distribute that particular copyright or you are exhibiting that particular copyright in public or importing it into India from other foreign countries, any infringement copies of that particular work, then it is called as infringement of the copyright. But however, it says bringing one copy of the work for domestic and private use is permitted, but you can use it only for a domestic and private work. Other than that, you cannot use it, use the copyright. So that was about the copyrights and what are the procedures. That is a procedure for registration of copyrights and the infringement of the copyrights. Now coming to the second important aspect in this topic, Intellectual Property Act, we have trademark. We have trademark. So trademark is the second point or second important aspect. So what is the trademark? Everyone knows a trademark is used in relation to the goods. You can see here. So in any of the product you can see there will be a trademark. The name of the person will be there or symbol will be there, something like this, or some pictures will be there like this. So a trademark is what? It is a mark used in relation to the goods for the purpose of indicating to the indication, so that or to indication the connection to the course of trade between the goods as well as some person having the right as a proprietor to use that particular trade. So trademark is what? It is the right given to the person who has manufactured that particular product, right? And the owner will be given that particular right, so that he can use it on his product or on the packet of that particular product or the boxes, so that it is easy for the identification as well as to say that this is a person, one who's legally, the brand when it is being legalized, it becomes a trademark. So that trademark is given to the person, one who has invented or brought a new, what you call the inventions or the new product or the product which is manufactured, so that he is having that particular right. So he can prevent it by using it from others. So the function of trademark is to give an indication to the purchaser or a possible purchaser as to manufacturer, or as I told you, or it may be the quality of goods, to give the indication in the eyes of the trader source, that is from which the goods have come, or the trade hands through which they pass on the way of market. So it is nothing but, this is nothing but a trademark is a brand name or the symbol, or it may be the alphabet, whatever it is. So that is when it is legalized. When it is legalized, automatically it becomes a trademark, and that is the right given to the manufacturer, so that no other person can use this trademark. Only that particular person has a right to use that particular trademark on his on part of his product which has been manufactured or which has been distributed. Now the definition trademark. So the definition of trademark says it's the mark capable of being represented geographically, where it says which is capable of distinguishing the products or the goods or services of one of the person or the manufacturer from those of others, that is their rival competitors, and includes the shape of the goods, or it may be the packaging or the combination or the colors like this. So anything can be there in order to identify and to distinguish that particular products of one manufacturer with other manufacturer, or with one competitor with other competitor, in terms of the shape, color, size, right, and packaging and combination of goods and colors. So firstly it says a registered trademark or the mark used in the relation of goods and services for the purpose of indicating it, in order to indicate that connection, what is the connection between this particular product and with the manufacturer, between the goods and services, and the case may be, and also some person having the right as a proprietor for that particular trademark. Now secondly it says a trademark used for the proposed to be used in relation to goods and services. It also means to indicate the connection again same thing, course of trade between the goods and services, and there the case may be, it says some person having a right either as a proprietor. So the person who's having the right, the trademark right, he is be called as a proprietor or the owner by way of permitting that particular user or the manufacturer to use this particular trade wherever or whether or without any kind of indication given, right, for the identity of that particular manufacturer or producer or that person. And also it says it includes the certification of trademark as well as collective mark. Now coming to the actual important topic, students, this is related to the procedure for the trademarks, registration of procedure of trademarks. I told you this can also be asked for 5 marks or it can be asked for 10 marks. So it is a weightage there. So please study this particular topic. Now the procedure for registration of trademarks. Now there are different procedures, various procedures. Let us see one by one. First is appointment of registrar and other officers. So here the central government, they will be appointing a person who is called as a Controller General of Patents. So central government they will be appointing a person called or officer called as Controller General of Patent, Designs and Trademarks, right? And this person or the officer who is a registrar of trademarks, this person will be the registrar of trademarks and the purpose of this act. So here the central government also appointed such other officers. They will be appointing other officers along with this particular officer called as the Controller General of Patents, Designs and Trademarks with such designations as it thinks fit. So with giving some designation to them so that it will fit in that particular place for the purpose of discharging the duties under this particular trademark under the superintendence and direction of the registrar. So under the superintendent and the registrar trademarks, the central government again they will be appointing some more persons who will be working under this particular person called as registrar. Now such functions of the registrar are under this act. Now secondly it says trademark registry and the phases thereof. Now under this particular procedure, for the purpose of registration of trademarks, what you have to do is there shall be a trademark registry. So in the office of registrar, there will be a register kept, and that register, that is the trademark registry which has been established under the Trade and Merchandise Act 1958, right? And there shall be trademark registry under this act, and the central government what they do may by notification. So they will give a notification in the official gazette defining the territorial limits within which the office of that particular trademark registry may be exercise its functions. So they will give you the directions and they will notify in the gazette. The central government will notify in the gazette defining, telling that the territorial limits, that which is that particular geographical area or the location where that particular registry or the office of the trademark registry should be located, and it has to function. So there shall be a seal of trademark registry also. Third is application for registration. Here it is very important, you need to apply for registration of a trademark. For that you need to put an application for the registration of the trademark. First and foremost, an application has to be made to the registrar. So you need to put an application to the registrar for getting your trademark registered. So a single application can be made for registration of a trademark as well as for different classes of goods and services by paying prescribed fees for each of class of goods and services. So along with the application, so if you have 2 or 3 products and you want different trademarks, then you can apply separately the single application along with the prescribed fees for each and every trademarks which you want or goods. Now in case or conditional acceptance of an application, sometimes if the application is not been accepted, the registrar shall record in writing. The registrar, what he will do, he will write that particular, he will enter it in the registrar in writing on the grounds for such refusal, why that particular application has been rejected for registration of trademarks in the registrar, or the condition for acceptance and the materials used by him. So all that will be entered in this particular registrar. Next is advertisement of application. If the application is been submitted and it has been accepted, so when the application for this at his decision, the registration of trademark has been accepted. That's what I told. After submitting the application to the registrar of trademarks, if it has been accepted, then whether absolutely or subject to conditions or limitations, the registrar shall, as soon as maybe after acceptance of that particular application, the application as accepted together with the conditions or the limitations, right, subject to which it has been accepted to be advertised. So depending upon the limitations as well as the acceptance, so the registrar, what he will do, he will enter it in the registry, as well as he will see that that particular application will be registered, that this person is, he is appealing, or he has been this particular manufacturer or the person or the trader wants to have this particular trademark, so that will be advertised. After doing the advertisement of that particular application of the trademarks from the particular from the registry or the registrar, the next point is, or a procedure is, opposition to registration. So any person may, within 4 months from the date of 4 months from the prescribed manner, from the date of advertisement given by the registrar of trademarks related to the trademarks of which has been applied by the trader, or the re-advertisement of the application for registration, give a notice in writing in a prescribed manner. So if for example, my friend has given the application for getting his trademark registered, and that has been accepted, and the superintendent or the registrar of the particular copy or registrar of trademarks, if he has accepted it within that particular limitation, everything is correct and it is validated, and it is sent it for advertisement, and if there is, after advertisement is given, if there is any kind of opposition by any of the third party or any other party, so that should be done within 4 months in a prescribed format. It should be given from the date of advertisement or the re-advertisement of the application for registration, and give a notice in writing. They should give a notice in writing that they are opposing to this particular registration of that particular trademark, and the payment also has to be done, such as fees may be prescribed. So according to what are the fees is being prescribed, they have to pay the prescribed fees, and also they need to give a notice in writing that they are objecting for this particular registration of the trademark to the registrar of opposition, and the registrar shall serve the copy to the notice of the applicant of registration. So in return, so the registrar, what he will do, he will receive that particular notice from the opposition party, and that will be served, that notice will be served to the applicant who has required or who has applied for the registration of that particular trademarks. That's saying that there is opposition on your registration of the trademarks. Now registration, and within 2 months from the receipt of the application of such copy of the notice of opposition, now the applicant, what he shall do, shall send it to the registrar in a prescribed manner a counter statement on the grounds saying that on which he realizes his application, that if he does not do so, he shall be deemed to have abandoned his application. And if the applicant sends such kind of counter statements to the registrar and serve the copy thereafter on the person giving a notice of opposition. Now next is any evidence. The next procedure is any evidence upon which the opponent and the applicant may rely shall be submitted to in a prescribed manner of prescribed format and within the stipulated time period to the registrar, and also the registrar also gives an opportunity to the applicant, to them to be heard, and thereafter the registrar, what he does, after hearing from both the parties, if it is required and they desire so, then considering their evidence, then deciding whether the subject matter to what the conditions and limitations are there according to the rule or act, and if the registration is been permitted, then he may take into account on the grounds of objection whether to rely upon that particular opponent or not. Next is registration of trademarks. So this section makes a mandatory on all the registrar to register the trademarks where the procedure for registration of trademark is completed. So here the application for registration of trademark has been accepted and dismissed, and either within that time period of notice of opposition has expired, or the application has been opposed and the opposition has been decided in favor of the applicant. So he has come in between, that is, there is a compromise between the opposition and the applicant, and the registrar shall, unless the central government otherwise directs, the registrar will not do anything here. So the registrar has said the trademarks, and the trademarks when registered shall be registered on the date of making that particular said application, and that date shall be deemed to be the date of registration. And next is registration certificate. So here on the registration of the trademark, once the trademark has been registered, the registrar will be issuing to the applicant a certificate that is in a prescribed format for the registration of his trademark, and that will be sealed from the trademarks registry, and here the registrar will amend the registrar or the certificate of registration for the purpose of correcting any clerical mistake or error which is obviously a mistake. The next is effect of registration. So no person is entitled right, to institute any proceedings to prevent or to recover damages or infringement of any unregistered trademark. So here the section will provide that no infringement action will be taken in respect of any unregistered trademarks, but it will recognize the common law which is prevailing, that is the right of the trademarks of the owner in order to take the action against any other person for passing of the goods, right, or as the goods from one person to another person, or as serving or services provided by any other person, or the remedies thereof. Now coming to the infringement of registered trademarks, a registered trademark is infringed by a person who not being registered proprietor. So the person who is not been a proprietor of that particular trademark, or the person using by way of permitted uses or uses in the course of trade, a trade may be which is identical with, depictively similar to. And also it says the trademark is in relation to the goods or services in respect of which the trademark is registered, and such manner or render the use of mark likely to be taken as a trademarks. What is the infringement for registering the trademarks? A person shall be deemed to falsify the trademark who is either without the assent of the proprietor or owner of the trademark makes that trademark or uses that particular trademark depictively in a similar mark, or falsifying any genuine trademarks, whether by alteration or by any addition to it or enfacement or any otherwise. So those kind of things will be infringement. It is called as infringement of registration of trademarks. Then a person shall be deemed to falsely apply to goods and service of a trademark who is without the assent of the proprietor of the trademark. Already the trademark is prevailing, but still another person is also applying for the same trademark. Then applies such trademark or depictively similar to the goods or any other person, or falsely it says applies to the goods or services any other trademarks. Then make, dispose or in his possession any die, block, machine, plate or any other instrument for the purpose of falsifying it, for using it as a trademark. Then applies any false description or goods or services, applies to any goods which is indicating in the country or the place in which they are being made to produce, or the name or addresses of the manufacturer, right, or the person on whom the goods have been manufactured, is required to be applied for false indication of country or name or addresses. So all these are related to infringement of registration of trademarks. Tampering with like alters or efface or indication of origin, causing any other things above mentioned which has been done, which will be punishable within the imprisonment of 6 months to 3 years, and also the fine with 50,000 rupees to 2 lakh rupees if you infringe the trademark. So students, these are the various important topics which I covered to you. So I had explained to you about the assignment of the copyrights, then I explained to you about what is trademark and what are the procedures for registration of trademarks. So on part of examination point of view, the procedure for trademarks is very important. So study that and surely you will get it for 5 or 10 marks. So thank you students. See you in the next session. Until then, take care. Have a nice day.